Hello, welcome back to my channel. We are still going through the February 2021 edition of The Light, a truth paper, an online free paper available on their website, also available in paper copy. So we are today, this I believe is episode 17 of February's videos. This is page 12 of the paper. And the article is entitled German Court Declares Lockdown Measures Unconstitutional. And this is translated by Northumbrian Nomad and from the source 2020news.de. Okay, so let's zoom in a bit. A district judge in Weimar has acquitted a man ordered to pay a fine for breaching the COVID contact ban by celebrating his birthday with at least 7 other participants from a total of 8 households. 6 guests too many, according to the Thuringia COVID regulation. The judge's verdict is damning. The COVID regulation is in breach of the Constitution and can be appealed against in material law. This is the first time a judge has engaged intensively with the medical facts, economic consequences and effects of specific policies. Part of the Rechtsstaat principle, the principle of the state acting in accordance with the rule of law, is the imperative of precision in legislation. Laws cannot simply impose across-the-board regulations, thereby affording authorities license to act according to whim, which would amount to arbitrary rule. According to the Federal Infection Protection Act, the relevant authorities are to impose the requisite safety measures. In normal times, this means that spreaders or persons suspected of spreading an infection may be isolated or contaminated areas closed off. The IPA does not envisage a general ban on contact also extending to healthy people. However, and this is the interpretation made by many administrative courts so far, it may be permissible to go beyond the purview of the IPA in the case of an unprecedented event that was so new that the legislator would have been unable to pass the necessary regulations in advance. The judge rejects this pretext. As early as 2013, the Bundestag had access to a risk analysis conducted with the participation of the Robert Koch Institute concerning a pandemic caused by a SARS-type virus, which described a scenario of 7.5 million dead in Germany over a period of 3 years, and discussed anti-epidemic measures during such a pandemic. It's to be found at Bundestag publication 17/12051. The legislator was therefore able, in regard to such an event that was considered at least conditionally probable, occurrence probability class C, to study the provisions of the IPA and, if necessary, adjust them. This political failure, as a result of which Germany went into the pandemic virtually unprepared, without legal instruments governing control of the virus, without stocks of masks, PPE and medical equipment, cannot now lead to politicians simply closing a gap in legislation as they see fit. Particularly given that an epidemic situation, i.e. the basis for the expansion of the routine infection protection provisions, simply does not exist, or no longer exists. The numbers of those infected and showing symptoms were already falling in the spring, way back in 2020. The lockdown thus came late and was generally ineffective. At no time, therefore, has there been a concrete danger of the health services being overwhelmed by a wave of COVID-19 patients. As can be seen from the DIVI ICU register, newly established on March 17, 2020, an average of at least 40% ICU beds in Germany were free at all times. In Thuringia, 378 beds were registered occupied on April 3rd, 36 of these with COVID-19 patients. Meanwhile, there were 417 beds vacant. On April 16th, 2 days before the issuance of the regulation, 501 beds were registered occupied, 56 with COVID-19 patients, and 528 beds were vacant. Thuringia registered its highest number of notified COVID-19 patients in spring at 63 on April the 28th. Thus, at no time did the number of COVID-19 patients reach a level that could have justified fears of the healthcare systems being overwhelmed. The estimate of the actual dangers from COVID-19 in the spring of 2020 is confirmed by an evaluation of settlement data from 421 clinics belonging to Initiative Qualitas Medicine, which found that the number of SARI cases, that's severe acute respiratory infection, treated as inpatients in Germany in the first half of 2020 was 187,174. Lower than the figure for the first half of 2019, which was 221,841, even though this figure included those SARI cases caused by COVID. The same analysis showed the numbers of ICU and respirator cases lower in the first half of 2020 than in 2019. The judge concluded that there were no unacceptable gaps in protection that could have justified recourse to across-the-board regulations against the federal government. It is striking how coldly the Weimar judge concluded the months-long discussion. And this is a quote I am about to read of the judge. A general ban on contacts is a severe intervention on civic rights. It is among the fundamental liberties of the individual in a free society to determine for himself or herself with whom, on presumption of consent, and under what circumstances he or she will make contact. Free encounter among people for all imaginable purposes is also a fundamental basis for society. The obligation of the state here is categorically to refrain from all intervention that purposefully regulates and limits this. Questions of how many people a citizen may invite to his home, or how many people a citizen may meet in a public place, to go for a walk, play sports, shop, or sit on a park bench, are categorically of no legitimate interest to the state. Much of the public has now almost come to terms with the new abnormal. However, as the judge points out, the life that was previously considered normal has now been reinterpreted as a crime. Although it appears that a shift in values has taken place over the months of the COVID crisis, with the consequences that many people find procedures that were formerly considered absolutely exceptional more or less normal, which of course also alters perspectives on the Constitution, there should be no doubt that by imposing a general ban on contacts, the democratic Reichsstaat has broken what was previously seen as a self-evident taboo. By the way, that was a quote of the judge, and this is also a quote. It must also be noted as an aspect worthy of special consideration that the state, in imposing its general ban on contacts with the aim of protection against infection, treats every citizen as a potential threat to the health of third parties. If every citizen is seen as a threat from which others must be protected, that citizen is also robbed of the possibility of deciding what risks to take, which is a fundamental freedom. A citizen's choice of visiting a cafe or a bar in the evening and running the risk of a respiratory infection for the sake of social interaction and pleasure in life, or of exercising caution because she has a weakened immune system and therefore prefers to stay at home, is removed under the provisions of a general ban on contacts. Okay, and that's the end of the article. Hope you enjoyed that, found it interesting. Please like, share, subscribe, and I'll see you next time. Bye-bye.